All right, today we are jumping into a really fascinating Supreme Court case, Weinberger v. Romero-Barcelo. And it's one of those stories that makes you ask a pretty tough question. What happens when a law gets broken? Maybe for a good reason. This is a case where you've got national security, environmental law, and the power of our courts all colliding in a big way.
So just picture this, right? You've got the military conducting absolutely essential training. But in doing so, they're technically breaking the pollution law. So what happens? Does the law just say, nope, shut it all down right now, no questions asked? Well, that is the exact high-stakes question at the very heart of this entire legal drama.
So our story kicks off with a real David versus Goliath kind of setup. You've got the U.S. Navy basically on trial, facing off against the people and the government of a small island. This was a true battle for the waters of Vieques. And believe me, the outcome was going to have some far-reaching consequences.
Okay, so who are the players in this showdown? Well, on one side, you have the petitioners. That's the United States Navy and the Secretary of Defense. Their whole mission, of course, is national security. And on the other side, the respondents, the Governor of Puerto Rico and the local folks living on Vieques Island who were, understandably concerned about their environment.
So what exactly was the conflict about? Well, for decades, the Navy had been using Vieques as a critical training ground. The problem was that during all these training exercises, bombs and other ordnance were ending up in the ocean right around the island. And legally speaking, that's a discharge, and they were doing it all without a permit.
And that brings us to the law at the center of all this, the Federal Water Pollution Control Act, or FWPCA. Now, the whole point of this law is pretty clear. It's to protect and clean up the nation's waters. And a huge part of that is a simple rule. You cannot discharge pollutants from what's called a point source, like a ship, or in this case, a military exercise, unless you have a permit from the EPA.
So, with the battle lines drawn and the law pretty clearly laid out, the case started its climb through the court system. And it pretty quickly turned into a legal tug-of-war that gave completely opposite results.
So how did this all go down? Well, first up, the district court took a look and said, yep, the Navy is violating the law. But, and this is a huge but, it also found that the training hadn't actually harmed the water quality. So the judge balanced things out and ordered the Navy to go get a permit but let the training continue. But then, the Court of Appeals saw it totally differently. They reversed that decision and ordered an immediate, total shutdown. No permit, no training, end of story. And with two lower courts saying completely opposite things, the stage was set for the Supreme Court to step in and have the final word.
So this all boils down to one huge question for the Supreme Court. When this specific law is broken, is a judge's only option to issue what's called an injunction, basically a complete stop order, or is there any wiggle room? Is there any space for a judge to use their own judgment?
And this, of course, is where the Supreme Court steps in. They took up the case, ready to balance the letter of the law against the very real, practical situation on the ground.
The court really zeroed in on this powerful legal idea called equitable discretion. Now, you can think of it as giving judges flexibility, the ability to tailor the solution to fit the problem. So instead of having just one tool, like a giant sledgehammer, they have a whole toolkit to help them get to the right and fair result.
And this gets us to the absolute core of the court's ruling. They said, look, just because a law is broken, that doesn't mean the other side automatically gets an injunction. For a court to be forced to issue a stop order, Congress has to write that into the law, explicitly telling judges, you have no flexibility here. They have to take that traditional discretion away.
Now, to really get why the court found this flexibility in the Water Pollution Act, it's super helpful to compare it to another law, one where that flexibility just doesn't exist. Turns out, not all environmental laws are created equal.
And this chart lays it out perfectly. The court looked back at another famous case, TVA v. Hill, which was all about the Endangered Species Act. Now that law has an absolute goal: prevent extinction, no matter what it costs. Its method is a total, rigid ban on anything that harms an endangered species. So in that case, the court's hands were tied. But the Water Pollution Act, it's different. Its method is a whole system of permits and penalties designed to get to clean water over time. That gives courts the flexibility to enforce the law without having to pull the plug on everything.
So let's just recap the Supreme Court's thinking here. First, they said the main goal of the law is the end result, clean water, not just blindly following the permit process for its own sake. Second, they pointed to the fact that the lower court found the water wasn't actually being harmed. And third, all of this meant the court was allowed to balance the technical rule-breaking against other huge public interests, like the absolutely critical importance of the Navy's training.
So, after all that, why should you care about this legal fight over a small island's waters? Well, The impact of this decision is huge, and it's all about the lasting power of a judge's flexibility.
At the end of the day, the big takeaway is this. Breaking a rule doesn't automatically trigger the nuclear option. Our courts have this power, this equitable discretion, to look at the entire picture. They get to weigh the violation, the actual harm done, and the public interest. And then they can craft a solution that actually makes sense, instead of being stuck with some extreme all-or-nothing choice.
And this all happened back in 1982. But don't think for a second this is just some dusty old case. This principle is still a fundamental part of our environmental and administrative law, and it affects how courts deal with complex regulations even today.
And that really leaves us with a pretty big question to chew on, doesn't it? This case was about a court using its judgment to balance a legal violation against something like national security. It makes you wonder, in our own lives and in our society as a whole, when is it right to bend a rule for what we think is the greater good?